Hear from Mike Stenhouse and Giovani Ciccone. I see by the bracket you want to testify as a team, so come on up.
Thank you, Mr. Chairman, committee members. Good to be back. I'll be very brief. Last time I testified, we issued a report about procedural. Today, I just want to make 2 points. Others are trying to paint this convention as something negative or dangerous for our state. And perhaps they should be reminded that this is a constitutionally authorized right of the people. As Governor Dorr called the very first convention our state had in the 1840s, he called it the People's Convention. So if opponents think so negatively of our state's people, then perhaps they should also be reminded that our government was designed to be of, by, and for those very same people. Many of us believe that the existing legislative process has been too friendly to many special interest groups, at the expense of the rest of us. A people's convention provides balance. It gives Rhode Island citizens an opportunity to exercise their constitutional right to have a more direct say in their democracy and in how their government can work better for all of us. We often talk about the checks and balances of the 3 branches of government. Well, a convention of the people could be said to be a 4th branch, providing that check and balance. Nothing to be afraid of, as Mr. Garabedian said. Holding a people's convention is a forward-looking event where ideas to improve our state government will be put forth. It's not a forum for our society to move backward by taking away other people's rights, most of which, by the way, are already protected by the United States Constitution or by Supreme Court decisions. To hear opponents resort to fear-mongering in an effort to shut down the voice of the people in opposition to this convention is exactly why now is the right time in our history to have a convention. Their power has grown too big, and they are determined to protect their turf. I find it remarkable to hear special interest groups complain about the prospect of other special interest groups potentially becoming involved in a convention. This should be viewed as nothing but self-serving hypocrisy. Second, and more technically, as we promised at the first hearing in my testimony, our center was working on a legal brief, which we did publish today, as to the eligibility of lawmakers. Your question, Ms. Jones, who may or should not run as a delegate. So we asked that question, and we have a lawyer here who runs a nonprofit legal entity we commissioned a brief for them. So here to present the findings of that study is Gio Ciccone, who's chairman of the Stephen Hopkins Center for Civil Rights.
Before you begin, Mr. Representative Lally, do you have a question?
No, I'm sorry, I meant to just speak directly with you.
Okay. Gio.
Thank you, Chairman. Thank you all for the opportunity to speak to you today. As Mike indicated, my name is Giovani Ciccone, and one hat I wear is as chairman of the Stephen Hopkins Center for Civil Rights, which is a nonprofit legal aid organization, essentially, that deals with constitutional questions and questions of civil rights on a volunteer basis. So when the Center for Freedom came and asked us to look into this question, we find it absolutely fascinating. I think even today we've had a couple of witnesses and members raise the issue of who is eligible to serve as a delegate to the Constitutional Convention. And I think what is most interesting is that in the time since the last convention, there's been a very significant and interesting case decided in Rhode Island that goes right to the heart of this issue. So I'm not going to read my brief in detail. I'm going to provide copies to the clerk. I will also provide copies of the case that we reference for those who might have the interest in reading Feltner v. Charahoe. But that case was decided in 2009. At the time, it was Acting Chief Justice Goldberg who wrote the decision. And Chief Justice Goldberg gave a very interesting roadmap on the history of what we call the doctrine of incompatibility, which is a common law doctrine that is directly applicable in a situation like this. I would also add that our state constitution has some very clear language in Article 3, Section 6, around whether a senator or representative has the ability to serve in another capacity. And there are some cases cited in Faulkner that go back to 1857, 1890s, that delve into that question with a little more detail. So I think there's an argument to be made that there's a clear constitutional prohibition in Rhode Island against a member of the General Assembly, at least, serving in two roles, especially if one might be viewed as subordinate to another in any way. But even if we were to take the, in my opinion, tortured reading of the Constitution and say that this doesn't apply to what is effectively a super legislative body like a constitutional convention, I think the underlying doctrine that language was intended to capture still applies as a matter of common law. And that's really what Justice Goldberg got into in her case. If you read the first half of the decision, she talks about the practicalities of conflict. In that case, Mr. Faulkner was trying to serve on a town council and then the chair of a regional school committee. And obviously there's budgetary implications and other things that might prevent or create direct conflicts. But in the end, her decision was, I think, most interesting in her addressing the incompatibility doctrine. And she makes the point that it was not so much a question of physical impracticality. You can't have 40 hours a week in two different jobs and do your job or serve your citizens or your constituents or other things that would be practical impossibilities. But it comes down to the inability to serve two separate constituencies and do right by both of them. And once you get to that argument, what it comes down to, and again, I'm trying to sort of abbreviate all this, what it gets down to is, are those two offices somehow connected in a way that there is a subservience from one to the other or an ability to alter one to the other? And if so, that means that under this doctrine, it is impossible to serve in both roles. Now, as a practical matter, what happens? What does that mean for us? Well, what happened in Faulkner was that the court decided, and based on very clear lines of case law in Rhode Island, that taking the oath of office, essentially, of that second office has the effect of resigning from the first office. So it's not that you can't run. In this case, it's not that you couldn't run as a senator or a representative for a constitutional convention delegate slot. It is that if you took the oath of office after succeeding in your election, you will have resigned as a senator or representative. And while that may be fine for those who view the Constitutional Convention as a much more valuable seat to hold, I would argue that, first of all, I think that you open the process up to legal disputes. I think there would be people that might hold on to their prior seat or attempt to at least. And that type of legal argument in the process of a constitutional convention can only demean the process. It can create uncertainty in the value or the sanctity of the process in the citizenry. And I believe that it is not a practical method to address the issue that our Constitution and common law lay out. I think as a more practical matter, the General Assembly should consider, and I would hope that this body would recommend to the General Assembly, or at least put out there, that Assembly members or others, by the way, who serve in public office, and I'll get to that point in a second, should be required to resign that position before declaring their candidacy for delegate. I think if you leave that door open, while technically legal, I think what happens is you end up with a process that might be multi-staged. You might have to have special elections. You trigger other problems if we have another provision in law that says you can't run for two offices at the same time. So if it was as suggested today, that we hold this constitutional delegate election along with a general election, then you'll have another issue with sitting reps and senators not being able to run for con delegate because of that provision. Interestingly, if you were to undertake a partisan election, if it was decided that this should be partisan in its process, you would then prohibit any federal employee from running. The Hatch Act, I think we're all familiar with. It doesn't prohibit political participation. It simply prohibits partisan political participation. So if somebody who is covered by the Hatch Act, and that goes beyond simply federal employees, but for shorthand, you'd want to consider whether or not you would like to bar those people by having this be a partisan election, or if you would like to open it up more broadly, at least in that sense, by having it be nonpartisan. And there are many more restrictions around the Hatch Act that I won't get into today. So that's the overview. I want to just hit on one more point here. We also get into the question of whether this incompatibility doctrine applies to municipal employees, other folks who might have a conflict. And although I don't think it is as clear-cut as it is with General Assembly members or state employees or officials, I do believe that there is at least a potential for a contest over whether a municipal employee could run for a con-con delegate seat without jeopardizing their position with the municipality. I think, again, it goes to the same issues that I've already raised, whether the issues that a con-con would debate would have a direct a revisory or supervisory impact on the offices that those people would hold. So, for example, a mayor of a town might be weighing in on tax sharing, on educational funding, on a variety of issues, both practical and structural, that I think under Justice Goldberg's interpretation in Felkner would be an inherent bar. And so any of those folks who, again, swore in as a delegate might find themselves out of a job or an office that they thought was compatible but is not under our state law. So I will leave my discussion of this at that. I would also, if I could just briefly make two other points based on what I heard in other testimony today, again, very briefly. I think Mike already mentioned, but I think it's worth repeating, and for this committee to highlight to some extent, the idea that there is no bar on the ability of a constitutional amendment to impact civil rights always needs to be tempered by reference to the U.S. Constitution. And in fact, our civil rights are not just a creature of the state; they are a creature of the U.S. Constitution, and I wouldn't say first and foremost, but certainly inordinately controlled by that document. And secondly, to Senator Hodgson's question relating to the practical matter of moral obligation bonds, our institute has looked at that question. We've weighed in on moral obligation bond issues in the past, and in particular the 38 Studios issues. I would suggest, Senator Hodgson, I don't have a clear-cut answer for you, but I would suggest that the best solution in the context of constitutional amendments to take the keys away, as you put it, is to look seriously at taxpayer standing as an issue. In Rhode Island, unlike many other states, taxpayers don't have a right to enforce the Constitution against a government that has in all its branches, ignored what we believe is a very clear issue. And I think that in particular in a state where you have such a heavily one-sided partisan balance, it's very hard for many of those general officers or others to go against some of their colleagues and to make a constitutional argument against the General Assembly or against an individual project. And I think, barring radical shifts in our political structure, which I believe me, don't hold my breath for, but I think that taxpayer standing itself could lead to at least a way to open those discussions if we can't get the Attorney General or if we can't get others to stand up and say, well, this is clearly contrary to the Constitution. Thank you.
Thank you. Chairman McCaffrey.
I was wondering, in your research, if you found out whether any sitting elected officials served in the 1986 or 1973 constitutional conventions.
I did not, and I found it fascinating to listen to the other witnesses on that point, but I was not part of our research, and we don't know that answer right now. I guess I blame the journal strike for that. I didn't realize that was why we can't find much when you go online.
Any further questions? Thank you, gentlemen.